Aspects of Music Reproduction, Copyright Infringement, and Music Piracy by Emily Connor, Melonie Jennings, Casey McKaskel, and Eric Nelson. The act of music copywriting and distributing is deemed illegal by the United States and is known as a federal crime. Music piracy basically means that one copies a piece of music that was made by another person and was copyrighted by that person or company. In this project, we will discuss the existing laws that attempt to discourage and prevent citizens from illegally sharing and reproducing copyrighted music. We will analyze certain statistics that show how frequent music piracy is in the United States. Why is it relevant? We decided to choose this topic because of how common the issue seems to occur and the lack of repercussions that accompany it. To be honest, a number of people we know or even ourselves have downloaded music before without thinking twice. The act of copying music has been present in our generation's lives for as long as we can remember. This can be recognized from the early days of burning CDs and giving them to our friends, or to us just now going online and downloading new music. Because this act is so common among us, our group decided to look at the laws associated with music piracy and reproduction and the possible consequences that it can have.
Some current issues relating to music piracy include Rocky Uprasith. Uprasith is 23, from Charlotte, North Carolina, and ran one of the nation's largest music file sharing websites. This website was called rockdismusic.com. This website was the largest illegal music sharing website in the year 2013. Uprasith found digital copies of copyrighted songs and published them under rockdismusic.com. He pled guilty this August to one count of criminal copyright infringement. The market value for this website was between $2.5 and $7 million. He is forced to give up $50,851 and pay $48,289 in restitution. Grooveshark was a website that didn't allow for downloads, but rather was a free streaming music service which used copyrighted material for users. Record companies did not give Grooveshark permission to use any of their music. Founded in 2006, Grooveshark provided streaming access to millions of songs for free. Grooveshark was sued in 2009, but they argued that they operated under the Digital Millennium Copyright Act, which protected websites that hosted copyrighted material that is uploaded by not the website themselves, but users. In September 2015, however, Grooveshark was held liable for infringement because its own employees were guilty of uploading copyrighted material themselves.
The reason why we chose our topic is to focus on music piracy so that we can inform people of the consequences that is involved with illegally downloading and sharing music. It is common now for people to download music illegally, however, the fine can be extreme. Making unauthorized copies of copywritten music is against the law. You can be subject to paying thousands of dollars or more in damages. Downloading and/or distributing copywritten music can lead to criminal charges, which could involve a felony record, accompanied by up to 5 years in prison. One woman in Minnesota was ordered by jury to pay up to $1.5 million for illegally downloading and sharing 24 songs. She was ordered to pay up to $62,500 for each song. The RIAA, also known as the Recording Industry Association of America, brought the lawsuit against the woman. The RIAA is an organization that represents the recording industry in the United States. How far can you legally use music without asking permission from the copyright owner? The fair value statute is what we look at. You just ask yourself these simple questions. Are you using music for commercial nature or for educational use? Are you using music to benefit the public or are you using it for personal? Will the use of the music affect the copyright owner's sales? Whether the use is considered fair value will all depend on specific facts of the use. Fair use is decided by the court on case-by-case basis. How long can you be in trouble if you were caught illegally downloading and sharing music? There are 2 statutes of limitations for music piracy. One, there is a civil statute of limitations, which means how long you can be sued by the music company, which can be up to 3 years. The other is criminal statute of limitations, which is how long you can face criminal prosecution for the crime in the music piracy, which is up to 5 years. In a law review analyzing the recent case about Robin Thicke and Pharrell Williams' Blurred Lines and Marvin Gaye's 1977 song, Gotta Give It Up, Maya concluded that artists may be liable of infringement if their work feels similar to another song. Thicke admitted to being inspired by the groove of Gay's song, causing Maya to question the difference between infringing on another's work and being influenced by it. On another level, Balganesh, Manta, and Wilkinson-Ryan coordinated a study on substantial similarity and interpreted their findings into an article. Substantial similarity requires the court to determine infringement by proving the works in question are qualitatively and quantitatively similar. In the study, jurors' initial decisions of similarity by comparison were swayed after hearing the facts about the case. Because of this, the scholars believe the requirement of proving substantial similarity in copyright infringement cases is questionable. Referring back to the Blurred Lines case, the jury found the two songs to be substantially similar. Maya believes that since Marvin Gaye's song had a 1977 copyright that only protected the composition of the music, admissible evidence should be limited to that and not the sound recordings of the two songs. He believes that a song's feeling or groove is not protectable. Music piracy costs the music industry $300 million per year. Because of this statistic, Maria believes music piracy is economically harmful. Initially, recording companies were suing those who facilitated music copyright infringement, such as the people behind Napster. Despite these attempts to stop piracy, music sales were still declining. This caused a shift to suing individuals who downloaded or shared songs. Maria believes that this is unreasonable and impractical, since a majority of those involved in downloading and sharing pirated music are college students who cannot engage in a costly and time-consuming suit. Ultimately, Maria believes that the best solution to stopping music piracy is to incorporate peer-to-peer file sharing into the music industry. She thinks peer-to-peer file sharing can be a beneficial tool for buying and selling music, made legal through the introduction of a low fee that is redistributed to the artists and recording companies. Additionally, she believes a system to compensate artists for creating music in the midst of all the piracy would promote social welfare. Finally, Liu questions whether artists have an economic motive to create new music, or if they create music for music's sake. If there were no copyright laws, like in China, what incentive would artists have to create? Liu thinks that having no music copyright laws would lower the price of music and call for the creation of music with the sole motive of self-expression. Music piracy has caused the music industry to be increasingly dependent on alternative revenue streams. Liu believes this will cause a shift in the music industry from traditional album contracts to focusing on touring and advertising. He concludes that while artists create music for music's sake, copyright law caters to and preserves the music market, allowing artists a broader sense of artistic liberty. We agree with the idea that substantial similarity in copyright cases is partially based off of a juror's easily distorted interpretation and therefore a questionable practice. In agreement with Maria, we also believe that suing individuals for illegally downloading or sharing music files is unreasonable. Recording companies and artists should be focusing their attention on large-scale piracy, not individuals such as Tenenbaum in the case of Sony versus Tenenbaum. Tenenbaum's attorney argued that the downloading was not deserving of blame. Rather, he simply discovered easy access to a vast database of free music. He did not intend to cause harm and did not understand the scale of his actions under copyright law. While it may be a controversial opinion, we believe that it is not at the same level of stealing. We also believe that his $675,000 worth of damages is unconstitutional.
In the last 20 years, the introduction of peer-to-peer sharing has created a new medium of music piracy. Current cases have warranted a new set of laws combating music piracy. Laws are getting stricter and the government seems to be cracking down on music reproduction, but there are still current issues regarding music piracy. Even though we addressed the legal issues of music piracy in our presentation, we also agree that there are some benefits to file sharing.